And now we are reaching the stage that our discussants kick in. First of them will be David Leary. He is currently a professor at the University of Technology in Sydney. I guess it's fair to say that he's always devoted his research interest to the cross-section of law and science. And he has published widely on that, and in particular, I think he wrote the first book on MGRs, marine genetic resources, back in 2007, so when the process of negotiations was starting, so to speak. So with that, David, may we hear your comments and reflections.
Thank you very much for that kind introduction. Your Excellencies, distinguished guests, ladies and gentlemen, I should, like the rest of the speakers here today, acknowledge the very generous support of the conference organisers in making it possible for me to be here today, and I'm very grateful for the invitation to come and talk. What I will do in the next 15 or so minutes, maybe I'm pointing this in the wrong direction. Oh, there we go. What I want to do is to pick up on the comments from our first two speakers in the panel with respect to three aspects I want to focus on. There's a lot that they've covered, so I think really I'd like to draw upon what they've had to say on these 3 points. Firstly, talk just very briefly about the scale of the commercial activity and what this means for benefit sharing. Then want to have a look at the example of the exclusion of fish and fishing, because I think that's quite a significant exception, and I agree with what our first speaker was saying in terms of the ambiguity that's there in those provisions. And then conclude with some very brief comments on the impact of regulation on marine science. And I know our second discussant is going to talk also about that aspect, because I think we have some similar concerns about what the impact might be. So without further ado, I guess we've heard a lot of discussion today of when the BBNJ process actually commenced. And from my mind, it actually commenced a lot earlier than what we were talking about. It would take us right back to, I think it was around about 1996 or 1997, I can't read the font there on the screen. This seminal article by Lyle Gloker, who at that point was a legal advisor to the IUCN in Bonn. And his very, very interesting article, and this is really where I became interested in the whole question of the status of marine genetic resources. He, in publishing this particular article, sorry, I'm just having problems with this clicker again, there we go. He suggested really that his motivation in writing this article was to alert the international community to the whole question of whether the status of marine genetic resources was something that needed to be considered by the international community. Really, he identified that we had, under Part 11 of the Law of the Sea Convention, there's a very comprehensive series of provisions dealing with deep-sea mining. Deep-sea mining was not then occurring, but we had an entire institution that existed. But in fact, what was being commercialised, or what was suggested was being commercialised, were marine genetic resources. So he raised the question very early on as to whether there needed to be an institutional regime design, which is now what we have in the BBNJ Treaty. I think it's really useful to revisit some of the points that he made in that article as a way of assessing the effectiveness of the regime that has been created. I'm sorry for my hesitancy, but I'm really having problems with this clicker. There we go. So he said essentially there were some questions that had to be answered before we commenced the diplomatic negotiations that resulted in the BBNJ Treaty. And that was, really, could we distinguish between marine scientific research and biotechnology development? what was the potential value or the potential usefulness of marine genetic resources, and finally, whether in fact there was any benefits that were ultimately going to be shared. So those 3 points I think are really important, because in the course of the negotiations, very little has emerged to answer any of those questions. And I think I personally have been very critical of many of the assumptions that have lay behind approaches to the negotiations of the BBNJ Treaty, on the assumption that there is a lot of money there to be made. So channeling our keynote speaker today, who spoke about the inconvenient reality, I think that's probably a better way of putting it than welcome to reality. I won't labour this point at length because it's something I've discussed on many occasions in the academic literature. What is the evidence for the scale of commercial interest in marine genetic resources exclusively from areas beyond national jurisdiction? It is true that there have been some isolated examples that we can point to of commercialisation of particular products, but in much of the debate there was a confusion and a conflation between marine biotechnology and marine genetic resources from areas within national jurisdiction with what was happening in areas beyond national jurisdiction. And this goes very much to those questions that Lyle Glocker was asking about the level of commercial impact and potential for exploitation. There were several studies that emerged during the course of the negotiations. All of those essentially concluded the same thing, and that is the evidence is patchy. We can point to a few examples, but whether or not there is a huge amount of money to be made there is something that still is very much an open question. Now, why does that matter now that we have a treaty that has been negotiated? Well, it matters very much because the assumption there is that there are benefits to share. That may eventuate on a commercial scale at a later date, but it's also important, I think, not only because of that fundamental question, but it also goes to the access and benefit sharing regime, and in particular the provisions dealing with the sharing of monetary benefits and also the financial mechanism under the agreement. I think one of the positive things I could say about the BBNJ agreement is that it's not relying solely upon a revenue stream related to access and benefit sharing. There are all the other sources of funding there. And also there is likewise the recognition of the role of non-monetary benefit sharing. So I think when we talk about the sharing of benefits, we have to be very careful in understanding the limitations of what might be there to be shared under these particular mechanisms, under Article 52, under the financial mechanism in particular. Now, turning just very briefly then to the question of fish and fishing, this I think is also another very problematic provision, which I understand the reasons why this provision is there, and I understand where they came from, but I think it does open up a very interesting question, given the lack of respect that fish show for international borders. Because, and to illustrate this point, this is taken from a project called the Iceland Ocean Cluster, which illustrates the great benefit that fish offer. In this case, we're talking about fish solely from within national jurisdiction, but you can see the many uses that can come from just one simple piece of fish. A fish fillet, maybe some roe, maybe some dried heads for the soup clearly comes from fishing, but there are also several examples now of biotechnology products that have come as the byproduct of fishing in the forms of enzymes, in the form of proteins, and a whole range of other products. And I think one of the most dramatic of those products is the potential, or the actual commercialisation, I might say, of fish skin as a treatment for burns victims. Very, very significant development there from, again, an Icelandic company by the name of COYE-FELSON, taken from cod. Again, I stress cod from within areas of national jurisdiction. And in this case, this is a particular individual who suffered absolutely horrendous burns from massive shock from electricity that in other circumstances would have unfortunately led to his demise. But because of the artificial skin that was created from cod, his life was saved. So this shows you the potential of fish for biotechnology purposes. Now, the other thing that I would just note as an aside, because I don't have much time left, is at the bottom of this company's website, there is reference to intellectual property rights. And as we heard from both speakers, intellectual property rights are an issue that is still very much unresolved. Now, I don't want to suggest that it was one singular product that did this, but this particular company was recently subject to a takeover where the takeover suitor was willing to pay $1.3 billion to acquire the company that owns the fish skin technology. So I guess, again, I've got to be careful, let's not conflate this happened in areas of national jurisdiction, but cod are one of those fish that don't respect international borders. So it could easily be a cod caught on the high seas to a cod caught within Iceland's exclusive economic zone. And of course, for this particular company, it's not just this one technology, but it shows you the value of biotechnology developed from fish that were originally fished in the conventional sense and therefore would have been outside the operation of the BBNJ regime. Now, I also want to pick up in particular some comments that were made by our first speaker in relation to the benefit of the treaty in terms of the, I think in your words, introducing greater flexibility to the system and a degree of ensuring a degree of checks and balances as well. I think, to my mind, that's also one of my main concerns about the BBNJ treaty. And this article here that was published in Nature around about the time the negotiations had not yet concluded, where some scientists really expressed concern about the heavy-handed nature of the regulation that might come out of the BBNJ negotiations. Now, I think in the end, what we ended up with was very much a soft touch in terms of regulation, in terms of the clearinghouse mechanism. But certainly I think those are very real concerns that some scientists have expressed about the potential for regulation with this flexibility that nation states have in terms of implementing its provisions as they think is appropriate and for those circumstances. Now, I am thinking here also of our experience with the existing provisions in relation to marine scientific research and the consent of the coastal state. And the approach of some states has been, to some extent, very heavy-handed in terms of how they have dealt with approvals. So I am concerned that the experience, and again, as our other speaker said, learning lessons from the past, I am concerned about the potential for some of those mistakes of the past also to be made by coastal states, or not just coastal states, but all states, given the flexibility they have to regulate consistent with the provisions of the BBNJ agreement. So that is my main concern there about the potential overreach that flexibility does bring. And I know certainly in terms of following, again from your comments, Professor MORGERA, about the desire and the need to talk to the scientific community, I think is a very important aspect. And I think that's what's really interesting about some of the work you have been doing. I think in much of the process leading up to the conclusion of the BBNJ agreement, there was too little consultation beyond some very tokenistic involvement by some leading scientists in the process. And although the mechanism we have under Article 12 is very light touch, I am concerned about how that might play out going forward. So with that note, and because I'm over time, as I always am, I'll leave it there and happy to, maybe we can discuss this in the more open discussion.
Perfect. Thank you so much, and including for offering a reality check from your perspective and reflecting on the case of fish. And last but certainly not least, Korea's own Dr. Mo, who is presently a senior researcher at the Korea Institute of Ocean Science and Technology. He has also published widely on BBNJ matters, so to speak. But also he was a member of the Korean delegation to BBNJ negotiations, so he also has hands-on experience on the topic. So with that, Young, please, the floor is yours.
Thank you, Judge Konrad. First of all, let me start by thanking Ministry of Foreign Affairs, International Tribunal for Law of the Sea, and Korean Society of International Law for inviting me to this conference as discussant. Deeply and truly, I'm honored to be part of this conference as well as this session. I think by now everyone knows how serious these panelists are, and then they had the pre-meeting last night, and then also we had another meeting in this morning and afternoon to arrange everything. I think there are advantages and disadvantages for as a last speaker, and overwhelmed by these speakers. The disadvantage is there's nothing left to say, but advantage is I can pretend by saying I agree with you, understand everything, and then I look very intellectual and intelligent. I agree with you all. By the way, I need to make few comments, just limited comments on both of speakers. And before I start my comments, I'd like to introduce where I'm from, what's my background. As a panelist in this time, I'd like to share my experience with scientific communities. Since the first BBNJ PrepCom, I've been working very closely with Korean scientific communities to get their opinions on this BBNJ negotiation. So I'd like to deliver. I'm speaking within my personal capacity, but I'd like to deliver the scientific community's concerns and opinions, and as well as ideas. Let me first comment on Ambassador Felson's. I really appreciate your presentation. Now I do understand what's the small developing island countries' concerns, and then what's your position. And but I think that Ambassador Felson, you might be surprised if I say we have exactly same concern, just from the different angles. So let me just give a comment on your tensions, on tension matters. First, potential loophole, we have same concerns exactly, especially this the sequence information. We don't have any definition. We tried, but we failed. But this is very key terms in BBNJ. I mean, if you look at the OMGR part, if we don't have exact definition or at least guidelines, the BBNJ MGR part will not operationalized in a proper way. So in other way, our scientist has very significant concerns on the definition of DSI. In fact, DSI is not the term used in scientific communities. I would say this is created by lawyers, maybe, or policymakers. And so most of scientific, when I heard this sequence information first time, I talked to my fellow scientists, and then they said, what does that mean? And they had no idea, because they never used this sequence information for terms. They used some other terms, like, for example, genetic sequence data or some other terms. So they still have some problem to understand, and then they just feel like a little uncomfortable. So anyway, we have this sequence information in BBNJ. So anyhow, we have to define. But in this defining process, I would like to suggest we really should base the term, we really define the term based on scientific practice and then based on scientists' opinion. I think that will give less burden on the scientist. And also, we have another issue is BBNJ batch identifier. Well, this was introduced at a very late stage of our negotiation. So I wasn't really sure what the definition is, and then it was very new terms to us, but it's here. So we should define batch identifier, and then we should have on the same page on this BBNJ batch identifier. And I suggest the same, instead of defining based on legal terms or legal practice. I'm sure we don't have legal practice though, but we should base our decision based on scientific practice and scientists' opinion. I think they are the one who should decide this definition and practice. And also fragmentation. Yeah, we have same concern, just a little different angles. When I talk to my stakeholders, the scientists and bioindustries, their biggest concern was not beneficiary. Their biggest concern was uncertainty and fragmentation. The reason it was their experience with the Nagoya Protocol was was burdensome to them, because if you think of marine bioindustry, you might imagine like a huge multinational companies or corporations, but in Korea, the average employees of the bioindustry are around 10. So it's more like a very small companies. It's more like a startup, and then they are trying to, they are more like a small laboratory. So they don't have any in-house legal experts in their own company. So if all the schemes and all the process get complicated, it will give them huge burden. So they want this order process unified, easy to follow, and clear. I think that was the biggest concern. And thirdly, this is a very difficult issue. I mean, Professor Leary just mentioned the intellectual property and disclosure of origin and then IP regime. And on these issues, even within domestic stakeholders, they have a little different ideas because the cosmetic industry, their cycle is very quick. So they are willing to disclose the origin, disclose of origin. No, they are not willing to disclose the origin because once they disclose the origin, other countries can catch up them very easily. But pharmaceutical, they are pretty much comfortable because it takes like at least 10 years to develop a product. So they are not really, they don't feel really uncomfortable with review the origin. But still, in overall, they feel uneasy on this matter. And about intellectual property, I think there are a little different ideas on intellectual property. I mean, I work with mostly scientists. For them, intellectual property is not for making huge profit, but for recognition. They want to get their recognition, and they want to keep their research result be protected. So even for us, like we don't want our article was paralyzed by anyone. So we want to be cited. I think they have the same idea. So there might be a little different views. But by the way, I think the MORGERA, after all, MORGERA provide us the way forward. I think it's on the striking balance. Anyway, we're advancing MSR for humanity. I think on this theme, I think everyone will agree because anyway, we need to understand, we need to have a better understanding of the deep sea and high seas in terms of MGR. So I think it's a good way to go. And then we are always welcome you to as a facilitator on informal on this matter. Okay, next. I'd like to go to the Professor MORGERA. I have to say this is quite challenging because it's a new area for me. It's human rights, and I never really thought about, connect the MGR with human rights. But it was very interesting. I learned a lot, and then I just have a few questions, 2 questions in fact, and then some comments. Okay, I just go follow by your flow of the presentation. First, there was a very interesting words. I think it's a lawyer thing. You use 2 words, 2 different terms. First, fair partnership and equitable partnership. I tried to figure out, but if you give us answer, what's the difference and what's the reason behind you use this term. And then regarding the interlinkage, I found this very interesting. And then you said ocean genome is essential. I agree with it. I can't agree more. But for me, ocean genome is also subject of research for the scientific cooperation. And then the research should advance if you want to make this ocean genome is essential for conservation and sustainable use of marine biodiversity. And I also agree with the relevance to the everyone. Yeah, PBNJ should be everyone's, not just particular group or not just particular people. I think PBNJ should be everyone, and not just for this generation, also for the next generation. And okay, also. Okay, I also agree with that there should be opportunity to all to contribute to the BBNJ scientific research. I think this is very important because we don't have enough researchers right now. even in the developed country, in developing country. And for example, taxonomists. So some call them like endangered species. And then many of them are going to retire, so we really need the taxonomist. But to raise one taxonomist, it takes more than 10 years after college. So if we start to raise the taxonomist, it's going to take at least 30 years. So we are talking about next generation. So, well, so I like to mention this. And of course, and then there is also very important issues, prioritizing allocation of a public resource. And then I'm sure you're right, and then we should allocate our public resource to research to understand deep sea, MGR and deep sea. But in my opinion, there is one more step before research. That's education, as I mentioned. If we do not give education, we cannot have researcher, which means we're not going to be able to research. So this is also, I believe this is also harmonized well with SDG target 14. And then I think there was another one is on page 11 of your slide about the beautiful benefit sharing diagram. Yeah, it is really helpful. But there is, I think I'd like to suggest if you create one more diagram, is diagram for scientific cooperation. I think it'll be really great for everyone to understand how we do the collaboration in this matter. And also, if we want to share the benefit, monetary or non-monetary, we have to create the benefit. And that comes from science. So that's why I'm suggesting. And then one more excellent point. Managing data is power. We didn't know we have power. You taught us we have power. Korea has a very good repository of MGR. But for us, we saw the repository managing data is more like obligation, not power. But now we know we have power. But my question is, to keep the integrity of the samples and the data system, we have to control and then we have to put some condition. So, and then the management issue is very important. So how, I mean, in what case you found is like a repository and managers using power, or if there is any way we can, resolve that issue. So I think that will be great for us. And that's about it. And then I just want to mention that your idea about iterative dialogue is a great idea. I think this conference can be considered as one of the iterative dialogue. Once we keep our dialogue, I think we finally found a solution, and then solution to the tension. In conclusion, I strongly believe that in implementing BBNJ, most important factor is science, because without science, we cannot make any decision. We cannot make any decision based on science, which means we are making some decision on something we have no idea. So I think in any way, in any case, science and scientific research should be advanced and go on. Thank you.
Thank you so much. I think it was amazing how you, not only you managed to tie back to the speakers, but also to the title of the conference and reflect on whether or not we actually have definition or not, notwithstanding the fact that we actually have some regulation. And you suggested that we should raise our kids as taxonomists, point taken. As promised, first I wanted to open up to the audience, to the floor, whether you might have, and I already see there is an appetite, so I will ask the organizers. So we'll start with Judge Hayter, and I think I saw Harriet Davis as well.
Thank you so much for a very interesting panel. In my earlier life, former life, I spent 10 years on PB&J from 2004 to 2014, so I'm not at all surprised that marine genetic resources are still somewhat unfinished business. So I wanted to just highlight Article 14, paragraphs 5 to 7. Article 5 sets out basically the goal that monetary benefits from the utilization of MGRs shall be shared fairly and equitably, but then the modalities have not yet been agreed upon. So this reminds me a little bit of UNCLOS, Articles 74 and 83, maritime delimitation. You have the goal of equitable solution, but you do not have anything about how to get there. And that is something that has been developed by international courts and tribunals, the ICJ, ICLS, arbitral tribunals. In this case, it is going to be for the COP to develop what was not possible to develop during the PB&J process. But what I find interesting is that in paragraph 6 there is this like a provisional funding setting out that that all developed parties shall make annual contributions to a fund for this purpose. And then it says at the end of paragraph 6, such payment shall continue until a decision is taken by the COP under paragraph 7. So paragraph 7 is about the modalities that should be negotiated at the COP in the future. And if it fails, then there's the possibility of agreeing with 3/4 majority. This is, I think, one of the final bits of the puzzle that were negotiated in the last hours of the negotiations, if my information is correct. So my question is basically to perhaps Janine and maybe to the others as well. What do you think are the prospects of the COP being able to settle what the PB&J process was not able to settle? And what would be the reasons why the COP would be in a better position to settle this than the negotiating process was? Are there any developments that will take place that will facilitate a solution by the COP on these fundamental questions? So just would be interested to hear your views about that. Thank you.
Thank you. And maybe we'll connect one or two more questions before we go. I think there was Harriet and anyone else?
Great. Thank you so much, Chair, and thank you so much, panelists, for that really thought-provoking panel, which gave me many questions and comments, but I promise I will pose two, if I may, with your indulgence. The first is to Professor Leary, if I may. I was interested in the concern that you elaborated about scientists seeing the agreement as overreaching, if I'm summarizing your words correctly. And I wondered if you could just say a little bit more about what those concerns are as you see them, and including sort of if there's any particular examples of where that overreach might be. And similarly, you spoke about tokenistic involvement of a few individuals as possibly contributing to some of those concerns, and if there's any comments that you could further share about why that happened or indeed what that tokenism looked like, it would be very interesting. And if I may, Chair, Ambassador Felson, thank you so much, as always, for your insightful presentation. And I was particularly struck by your point about relational approaches and reciprocity. And I wondered if you had any thoughts about the potential to further explore that issue of reciprocity in further bridging some of these persisting divides in the MGR issue. Thank you so much, Chair.
Thank you, and I haven't spotted any other questions. No, so the floor is yours. Perhaps the first question by President Hayter was with some direction, but not exclusively to yourself, and then Harriet. So please, Janine, maybe we will start with you.
Thank you very much, and thank you for the questions. Will the COP be in a better position to address the issue of modalities than the negotiators were? And I just want to quickly reflect to what Professor Leary mentioned about certain assumptions that were made or maybe even debunked regarding potential of monetary benefits from commercial activities or utilization of marine genetic resources. And I think the whole point of having this period of time over which we would be collating or collecting information through this notification system, aggregating it as it were by utilizing different functions like the BBNJ identifier, I think it gives us that opportunity to in fact determine whether or not there are benefits. So whether or not the COP will be able to do it is anyone's guess. But I think at the point of time that has been created through this process that's codified in the agreement, it will be in a better position than the negotiators were able to decide at that point. Regarding the relational and reciprocity and how potentially that framing could assist with some of the issues that we're addressing right now, or will have to address with respect to implementation. First, let's take up the issue of digital sequence information, which there is no universally agreed definition, but there is quite a bit of work that has occurred around it. And I think there is also a recognition that there are different ways and means of producing knowledge that potentially could be relevant to, well, I have to use DSI because that's the terminology we have, even if scientists don't necessarily use that in their common parlance. And I think in that regard, I think there needs to be a consideration there of, well, where exactly there are potential for communities or researchers from certain communities or certain countries to be able to benefit from an understanding of what comes from digital sequence information to contribute to their own efforts on conservation and sustainable use. And so I think there is that built-in reciprocity already within the agreement, but it is more in terms of operationalizing. When it comes to the whole discussion around fish and the fishing exemption, again here I think there needs to be some some safeguards that are put in place necessarily to address this potential or the potential of a major loophole, I guess. And I think Professor Leary already showed a very helpful diagram of all the different ways in which fish, which would have been caught in a fishing-related activity, could then be the genetic material from that marine resource could be used to produce other things that would count as utilization under the BBNJ agreement. Here again, that whole concept of the relationality or the reciprocity needs to be borne in mind, and it would be interesting to see, and I guess this would probably come in relation to the Access and Benefit Sharing Committee, how the Access and Benefit Sharing Committee might be able to establish certain parameters in consideration of addressing safeguards to avoid these potential loopholes that the BBNJ agreement with the provisions as vague or skeletal or framework related, how it might be able to provide some guidance on implementation. I think I'll leave it at that. Thank you.
Elisa, you want to take any, reflect on any questions?
Thank you. Maybe on this very question, I'm wondering if, because of, I think as David has mentioned, there was a certain degree of a limited participation in the BBNJ negotiations. Maybe the creation now of the Benefit Sharing Committee as then advising the COP on the development of the modalities can provide a forum where there is a bit more time and a bit more openness to different inputs, including from different scientists, again, not only the natural sciences, but also the social sciences, particularly in addressing questions related to fairness and equity and representation from scientists in the global north and south, to give a deeper sense of what the practices are and what would be helpful for then those modalities to capture and respond to. And I think that kind of also links a bit to the problem that Harriet raised around, is this regime going to be overly intruding into scientific practices? I mean, in my engagement with marine biologists, both from the UK and South Africa, they're actually quite keen for the agreement to help address a need, for instance, for some harmonization, including of data, interoperability, and practices, because that would make it easier for them to then engage in the negotiations that can be quite tricky in developing plans for research, managing funds, and finding themselves in a very actually highly competitive environment to obtain and manage those funds for deep sea research. And that kind of maybe links to that comment that was made by the second discussant around why reference to fair partnership, because I think there's an interesting area of convergence here between research ethics and trying to understand what we have been able to achieve with more maybe voluntary approaches, as opposed to the need for clarity, including legal clarity around minimum standards of conduct, both in terms of what individuals, researchers, and business entities may do, but also what states need to do as regulators of science, of public research funding, to create the enabling conditions for more equitable research practices, which hopefully in and of themselves are actually a form of fair and equitable benefit sharing, but can also contribute to understanding what else is needed for that benefit sharing mechanism to really make a difference in terms of who contributes to advancing ocean knowledge and who helps to develop the evidence base for better conservation and sustainable use within and beyond national jurisdiction. I think I'll stop there.
Thank you. David?
Yeah, thank you. So I just want to clarify that article I referred to from Nature, that was at a point in the negotiations where there was concerns expressed by some of the scientific community. As you said, the scientific community very pleased to see that the agreement is going to come into existence, and looking at that article in particular, there's specific scientists who are quoted and say, we're really pleased that governments and the UN are now looking at what we need to do in the high seas. This is fantastic. But we're concerned about the potential for overreach and what that might mean in terms of the way that we conduct scientific research. I think what came out of the negotiations in the end was much better than the position we were in at that stage of the negotiations. But nonetheless, I think the point is scientists just want to do science, right? They want to be advisors, they want to contribute, they want to provide the science that good policy making should listen to, acknowledging that actually it's more often than not science is not listened to by policymakers. But if you have excessive intrusion, you have to have a cruise report that has to have, that long list of the provisions of everything that must be notified through the clearinghouse mechanism. There's a lot of things in there, and if you make a slight change, or if you make a change, I won't say a slight change, if you make a change, you have to file an update. Okay, so it's concerns about it being a process that is overly bureaucratic, and because of the flexibility that is now built into the system, there will be some states who will require even more than that. Some very constructive interpretations of some of these provisions in other contexts. I'm thinking, to my mind, the best example of, not talking about science, but talking about benefit sharing, of a particular jurisdiction that in its legislation implementing access and benefit sharing said, well, of course, any pictures that are used in a movie about this particular plant, we'll regard that as something subject to the benefit sharing regime. So you can see with some rather creative interpretation of some of these provisions, you have many sorts of activities that are caught that shouldn't be. So science, I think, scientists just want to get in and do good science. They want to be listened to. They want their work to feed into those processes. but ultimately they'd just like to get on with doing science as well. My comments in relation to tokenism, first-hand experience from one individual who I won't name, said to me on repeated occasions, they invite me to come and talk, but they don't listen to anything I have to say. You know, why don't these people just get, this is not how we do it? Okay, so it's those sorts of concerns that the scientific community have. Just one comment back though, just if I might, in relation to your comment in relation to the time going forward. I think that's really pleasing to hear, that going forward in terms of trying to analyse what the market situation really is for marine genetic resources. That's really good if that's going to be what's going to be happening now. My concern is we've designed a whole legal regime without fully understanding the industry that we now seek to regulate before that, which is a little bit back the front to how we would normally approach any sort of regulatory issue, where there is a problem, there is an industry, we understand the industry, this is how we're going to regulate it. Now we're saying we've designed the regulation, now we're going to work out what the industry is actually doing. That's just a little bit concerning to me.
Thank you. If I may move outside a little bit of purely moderating, just to reflect on what President Haida said, and I'm grateful he drew attention to this one particular provision, which is relatively novel, I would say, and progressive in terms of benefit sharing. One way of looking at it is it could still be a negotiated outcome. It's just it would manifest itself in a different form. So it would not manifest itself in the treaty text, but it would manifest itself in a COP decision, or at least one could argue, or hope. And referring back to what David just mentioned, I just wonder, because we had a very impressive number of signatures. We are awaiting ratifications, and I wonder to what extent, and also what the title of the conference relates to the regulation, how far that will impact ratification, because obviously ratification procedures differ across states and national legislations differ as well. But I guess it would be that before you can ratify, you have to have all legislation in place as a state. And this is clearly a treaty that would likely require some legislative action on behalf of states, unlike perhaps some other treaties. So that may play in. But having said that, and going back, Young, would you care to comment as well?
I've never been asked, but I'd like to answer to President Haida and then Professor Davis. First of all, the COP, whether the COP is the best place to decide modalities. Well, within the time limit, I think there was only one option we could have. We had to have, to get the agreement done. But now I think I'm start to see at the bright side, because once we have a COP, we will have more experts involved in. So I think we will have more, better modality based on the reality. That's my hope. And so I think it may be not the best, but not bad choice. And then back to the Professor Davis, I think the scientist's concern is, their biggest concern is we have scientific practice, its practice is proven effective, but their concern is what if the regulator comes in and then distort the practice? So they have to do everything again, they have to build a new practice, and then the new practice is burdensome, and then they feel, they are not able to do the research as much as they could. I think that's the biggest concern. So if we persuade and we reflect in the practice on the regulation, and I think the problem will be resolved. Of course, we need to give them time for them to understand and then get used to new schemes. Thank you.
Thank you so much, including to the audience for participation, and both to the speakers and discussant for interaction. It was really lovely from my perspective to see you actually talking to each other, and not only to the audience. And I congratulate you that you managed to do so. I think we're like 1 minute before our times is up, so I guess we should slowly but surely wrap up this part. And I think, I'm sure the audience will agree with me that we owe the speakers a round of warm applause.
Thank you, Judge Marciniak, and gratitude to all our panelists for the discussion and also the participation from the floor. Ladies and gentlemen, once again, please applaud all the speakers and the participation and our moderator.